Good evening, everyone. I'm glad everyone is in attendance today. My name is Yvette Dudley. I'm with the Medgar Evers Dubois Bunche Center for Public Policy. The center essentially produces and studies research and compiles data, and we compile reports and conclusions on issues of housing insecurity, housing instability, voting rights issues, and proper representation. We also provide legal clinics, and we represent litigants in court through our legal arm. We're presenting this estate planning program because we believe it's very, very essential for not only acquiring real estate, maintaining real estate, and we're here because we want to properly transfer our wealth and continue the wealth in our communities and in our family, which is the way we empower ourselves, our family, and our community. We have co-sponsors. We have a co-moderator. My co-moderator is Jace Forbes. Jace Forbes, just a little bit about her. She is the chairman of the Neighborhood Housing Services of Jamaica. She also sits on the board of Queens County Women's Bar Association, and she's with the Macon B. Island Black Bar Association. She's an attorney. She also handles real estate issues and bankruptcy issues as well. So Jace Forbes. I also want to introduce our co-sponsors. Our co-sponsors, we have Neighborhood Housing Services of Jamaica. And I'm going to introduce them, and a person's going to say a little bit about each organization. We have Neighborhood Housing Services of Jamaica. We have the United Neighborhoods Civic Association, and we have the Macon B. Island Black Bar Association. So we'll start with the Neighborhood Housing Services of Jamaica. Laurie Miller, are you on? She may not be on yet. So we'll jump right to Joyce Denny of the United Neighbors Civic Association.
Good evening, everyone. I'm Joyce Denny. I'm the president of the United Neighbors Civic Association of Jamaica. It's good to be with you all this evening, just to give you a little idea of the United Neighbors Civic Association. The United Neighbors Civic Association is located in the Baisley Park area of Southeast Queens. It was created in 1954. Our mission is to advocate for the community, bring services to the community, and to assist people in the community who does not have the ability or would not want to approach the difficult situations that sometimes we have to deal with regards to speaking with our public officials, collaborating with the precinct, and bringing services such as health, informing people of health situations, education, guiding them towards those different organizations such as education, policing, and such. As a matter of fact, such certain things such as the Gateway bid, the JFK development, we collaborate with them on many issues and many outreach situations for the community. And thank you so much, Yvette, for having us and collaborating with us on this event. It's an event that is very good for our community. I think it's going to be very informative. Our community needs more of this. So I thank you again and your colleagues for working with us on this event.
Yes, you're welcome. You're welcome.
Thank you.
And to say a little bit more on the Macon B. Island Black Bar Association, we have the co-moderator, Jace Forbes.
Hi. Good morning. It's actually Jace Ford. I think she's getting a little confused because we have a Carl Forbes and we have a Jace Ford. But Jace Ford, I am the corresponding secretary for the Macon B. Island Black Bar Association, the as we affectionately call it, MBA-BBA. We are the Black Bar Association for Queens, and we are focused on new talent, bringing in, recruiting, mentoring, young attorneys and aspiring attorneys, as well as activism in the community and the education of the public and of ourselves as attorneys, and the improvement of our practice. We never feel that we know everything, so we offer CLEs. We meet every second Thursday of the month and share our insights as to the practice and where we see the practice going. So that is our role, and we were very pleased to be invited to co-sponsor this event. And I should also point out that Everett Hopkins, which I'll read in his biography, but he's the chairman of our board.
Thank you, Jace Ford.
Thank you.
And I know that because I say your name all the time.
I know.
I have to write. And Erin, do you have your hand up?
Oh, no, I was just applauding. You're on mute, Yvette.
Yvette, you're on mute. Okay.
I was muted. Jace, is Willa on or not yet?
Let me see. I tried to reach her.
We'll circle back with her towards the end.
Yes, correct. I think that's appropriate.
Because we have a surprise for everyone at NHS, so that it works in that favor. So we're going to move forward with the program.
Okay, so I'm going to introduce our first speaker, Mr. Everett Hopkins. Everett Hopkins is currently the managing partner of Hopkins Law Group, formerly Hopkins, Lawrence and Bailey PC, a law firm in Southeast Queens providing legal services to his community for over 30 years. He received his undergraduate degree from the City University of New York at Hunter College in 1979 and earned his law degree at New York State University of Buffalo in 1982. During his career, he served with distinction for 8 years as general counsel and director of administration for the New York City Criminal Justice Agency, that's CJA. During his time at CJA, he played a critical part in advocating and developing policy to release arrestees from detention pending the outcome of their case. Prior to this position, he held key positions with the New York City Housing Preservation and Development Department, HPD, for the enlargement of affordable housing and with the Internal Revenue Service Enforcement Division. He currently serves as chairman of both the Black Spectrum Theater in Queens, the Macon B. Allen Black Bar Association, and as a member of the Mayor's Advisory Committee on the Judiciary. Mr. Hopkins, who has been a resident of Southeast Queens for 66 years, has always desired to work with his own community and become an entrepreneur following in the footsteps of his father, who has maintained a barbershop in the community for over 58 years. Mr. Hopkins has served thousands of clients, inclusive of 3 generations, since he began practicing within his community and has become a staple in the community for residents to obtain legal counsel and services. As a proud member of the Alpha Phi Alpha fraternity and the 1906 Project, his desire has always been to develop and represent families and businesses in his own community and to inspire entrepreneurship. In the past, he has represented both domestic and international corporations from the New York to the West Coast of Africa and has the distinction of assisting in the development of $35 million pharmaceutical plant in Ghana, Africa, to produce HIV antiviral medicine in West Africa. Over the past 20 years, Mr. Hopkins has served as an adjunct professor at Baruch College and Medgar Evers College, York College, and the College of New Rochelle, teaching taxation, business law, real estate law, bankruptcy, and urban development. His office routinely counsels and litigates matters in real estate law, probate, wills and estates, landlord-tenant, and guardianship. Everett and his wife, Audrey, who also manages the law firm, are the parents of 2 sons. The eldest son, Everett Corey Hopkins, is also an attorney, a criminal defense attorney in Queens Legal Aid Society. And the younger son, Dr. Justin Scott Hopkins, is a clinical psychologist in his own practice in Washington, D.C. Everett and Audrey are also the proud grandparents of 3 grandchildren, Everett Alexander Hopkins, Wesley Maddox Hopkins, and Marlo Simone Hopkins. And with that, I turn the floor over to the esteemed Everett Hopkins.
Good evening. Thank you for that. I almost don't recognize that guy, but I appreciate the introduction. So hello to everyone. My part of the presentation tonight will be talking about wills and trusts. And I have to say that it's something I learned over the years and glad that I did, because as mentioned, I'm in the middle of my community next to a barber shop my father owns. So everything walks in here, especially now as I matured with my client base, dealing with all sorts of issues when it comes to people making their advance directives, and also sometimes tragic events when people pass away when their affairs are not in order. So I'm going to go over just a few things with regards to um, wills and trusts. And I understand we're going to have a Q&A and at the end of all of this, I'll touch what I can, and you'll hold your questions until then. I did have a little bit of an outline, which I'll go from. If they can put it up, it's fine. If not, you can all listen and take notes. Now, I'm going to start off with wills because most people always think about wills, although they may never get to trust, but they think about wills routinely. And just so you understand, wills in New York State must be written documents. A lot of people think that they can have a will, which would be a holographic will, which won't work here in New York. There may be a few states left. I remember when I was in law school, you could do it in California. I'm not sure that's still the case, but it's always best to have the written document. So you say, well, what happens with a will? Well, first of all, what you should think about is if you're called home, who do you want in charge? That's very important. Who do you want in charge? Because you need someone who is able to really move things along, who knows you well enough, at least has a working knowledge of what your assets are, but you trust that they'll get it done. The other thing is you should have someone who may be fairly tough, depending upon how your family is or who you're leaving things to. If you have a lot of people in your will or several children, you really need somebody to get things done. Now, if you want to pick a child, that's fine, but they have to be the child who's able, who's ready, and is willing to take on a few challenges. Because nowadays, usually there's always friction when people pass away. It's not as simple as it may have been years ago. Almost any will that I submit now for probate, if it's more than two people inheriting, it's always a problem with somebody. If you have two or less, you got a shot. If you have two, you got a shot. But if you have more than that, it's almost always there's some kind of difficulty. Usually it's based on real property, though, which we'll come to in a little bit. Because if there's a home left, usually you have one person who has more use for the home than the others. The others want the house sold. One wants to live in it, although you may leave it to all people, and that becomes really a fight. So I always tell people to determine who it is that you want to put in charge, especially if it's a will, and also someone to back up that person if they're unable to serve. So you don't just pick one person, you pick two. You pick one to move things along. You pick a second person as a backup if they choose not to do it. And that does occur from time to time. You can also have co-executives, although I don't really favor that, because if you don't have two people who can work together, not only work together from the standpoint that they get along, but they can actually work together. One's not waiting on the other. So I usually recommend you have an executor. So the question now is, what happens if you don't have a will? Well, then the laws of intestate succession take over, and you may not like what that does to you. When we talk about the laws of intestate without a will, intestacy without a will, which means it'll pass by your heirs by statute. Generally, that means if you have children, then your children will all inherit. If you have a spouse and children, then that means your spouse will inherit a little bit more than half. The statute says $50,000 plus half, and then the other children will receive, or the children will receive the other half. Now, if you don't want all your children to receive, then you definitely have to do a will. Now, one of the things people do believe is that you have to leave your children something. That's not true. In fact, you can totally remove your children from your will if that's something you want to do, or a child. And it may be for good reasons. It may be because they're disabled or you've taken care of them some other way. You can't really remove a spouse. Well, you can, but they can object to it because a spouse has a right to receive from the deceased or predeceased spouse. They certainly have what is called an elective share. So if you do a will and you leave your spouse out, the will can go through that way if they fail to object to the will. And they have to know they have to object to the will, and then they have to do it. If they don't object to the will will go through and the spouse can be left out. Some people don't know where their spouses are. I've had that happen from time to time and leave them out. But what I will tell you is the spouse who has disappeared usually shows up when the person has passed away. They seem to keep an eye out for those sort of things. But I also tell people who are divorced, they really should think about their wills as well when it comes to their children, because a former spouse can still inherit through a child of yours. If a child of yours becomes deceased and you don't make a provision for what happens to a predeceased child, then a former spouse could actually inherit through that child. Now, we said that the will must be in writing, but the problem with wills, although I say everybody should have a will, but you should have more than a will, but we'll get to in a few minutes. I always love to have people come in and do a will and a trust. Now, the thing with a will is it does have to be submitted to probate, and that's a whole process. I believe there's someone else who will be speaking. I believe Mr. Forbes is actually going to speak on the process of the will. But with regards to the will, the issue with the will is that it has to go through a probate process. It has to be submitted to court. The will has to be proved. Those involved have to sign waivers. The other thing about a will is that for those who would receive, if the will excluded them, and would receive if there was no will. So for instance, someone in line to receive from you by statute, if they're not getting anything under the will, such as a child or a spouse, I said a spouse could object, but a child can also object as well, because by statute they would receive. So if you exclude them, they can object. Now, it doesn't mean that they will win. In fact, most will contests, if you're willing to fight long enough, the will stand. The problem with that is it may take a long time. So what I will say to you is that you need to consider other things but wills. But coming back to the process can take a very, very long time. And that's why people object, because they frustrate the process. And very often people decide to say, well, I'll give them something just to make them go away. So that's why people object to wills. Now, a lot of people always say, isn't there a reading of the will? No, that's Hollywood. The way it works now is you will receive a copy of the will with a waiver in most cases to see if you want to sign off on it and agree to let the will process go through. Now, I will tell you also with wills, people who do wills, you have to be careful. One of the things people do with wills sometimes is they take them apart to copy them, and that's not a good thing to do, because a will can be invalidated if you ever take the staples out of it. You should try not to, if you do a will, to ever take the staples out of it, because then you have to explain why. Now, it happens, and very often you can simply say it was taken apart to copy it, but then you give grounds for another person to object to it. All right. Now, since the pandemic, surrogate court has been backed up. It's getting much better now. But when the pandemic hit, some of the wills I had filed to go through probate actually took about 3 years. And they shouldn't have, but it was really just a backup. And for those of you who are in Brooklyn, not that I like beating up on courts, but Brooklyn can be a very slow court to get anything through. So that's why, again, you have to have advanced directives and other instruments. Now, although I say everybody has to have a will, one of the things I will tell you is that a will should only be used really as an insurance policy if everything else fails. So what I tell all my clients to do is create what I call testamentary substitutes. And what does that mean? That means put beneficiaries on things, as many things as you can if you don't put it in a trust. So of course, life insurance, you have beneficiaries, but you can also name beneficiaries on bank accounts, okay? Generally not checking accounts, but certainly savings accounts, annuities, 401ks, any sort of investments, almost all of those items you can name a beneficiary on. So what does that do? That means that passes to those people automatically, whoever you leave it to. So although you may have the wills there to ensure that they get a part, if not all of your estate, what you want to do is avoid the process of having to file a will and go through probate with it because of the time and the unnecessary expense that goes along with it. Also, when you do your will, make sure you put it in a safe place. Now, a lot of people put it in a safe deposit box, which I don't necessarily recommend, because when you put a will in a safe deposit box, no one may be able to find it when something happens to you. You should put it in a safe place, but then you have to go to court to get an order to open up the safe deposit box, okay, when something happens. Now, if you do a will, I would make sure that you take a moment and read it and make sure that you have what is called an affidavit of attesting witness with the will. Some attorneys do not prepare affidavits of attesting witness. They let you sign. It is witness, but the affidavit attesting witness is not attached. More and more I see attorneys are not doing that, but I've run into it in the past. And what that means is to probate the will, you now have to run around and find those witnesses who witnessed the will some years ago. And although they signed their name at the end, they didn't do what's called an affidavit of attesting witness, which indicates that they saw you at the time, they signed it in front of you, you signed it in front of them, in front of the other witness. You were able to read, write, and converse in the English language, not suffering from any defects, and that basically you were competent to sign the document. So I say to you, if you do go do a will, or whoever you do a will with, make sure that that's attached to it. You can also talk about where your remains should be sent or how your funeral. There's some people who actually put in their will where they want where they want their funeral held, who they want to attend even. I've even done wills where they ask people to be excluded. I don't know how you do that, but they've asked for it. They've asked for certain music to be played at their funeral and who they want to funeralize them. All of that can be done once again by will. But basically, you can say whatever you like in your will to give away whatever assets that you have and to whom you want it to go to. You can even ask that those assets are put into a trust and that the trust governs where they go. So you can actually ask even after death that your assets be put into a trust and not given to people. And maybe those assets are held in trust for a while until those people reach a certain age, or that you want it to be dealt out over a period of time, such as money, and it's held by a trust and the trustee so they don't get all their money all at once. There's no one way to do a will. It can say a lot of different things and have a lot of formats, but just make sure it's in writing, witnessed by two people, okay? And that affidavit of attested witness is done. Now, again, I don't mean to proselytize what all the attorneys are on, but a lot of people go to websites and do wills. And that's your choice to do that. But I can tell you, if I see 5 of those wills a year, 4 of them are not properly executed. And the problem is people just think, oh, I just wrote down something, someone witnessed it, and that's it. Well, it may not have been executed properly, may have not been signed right, or they only have one witness, that sort of thing. So I certainly suggest that you consult an attorney to do that. The other thing is that I'm coming to now trust. What about trust? All right. Now, I said to you, again, everyone should do a trust. I mean that. But where I come from now and the things I'm beginning to see just through experiences, not simply what I'm reading, if you don't do a trust, and certainly if you have any kind of means, and what I mean by that is I include certainly real property, because a lot of people have real property, although they may not have a lot of cash, and that's worth a lot of money now here in New York City. Even some have several pieces of property. The sad part that I'm beginning to see is that we're losing, particularly in the communities of color, a generation of wealth. And we're going back to zero because people have either annuities or certainly real estate that they've paid for, has no debt on it, and they forget to plan. They end up in their later days of life running up a lot of medical bills, or they end up in a nursing home, or they get care at home and they apply for Medicaid, which I believe Tanya is going to speak about tonight. So the bottom line is a trust can protect what you have, what you own from the government, if you prepare enough in advance to make sure you kind of disassociate yourself from your assets, but it's still certainly somewhat connected with you, but controlled by your trustee. And of course, you have to find a trustee that you trust. A lot of trustees are the children who end up being the beneficiaries of whatever's in the trust. But what I'm very sad to see is people who walk into my office, and it's usually the children who believe they've inherited something, and they find out that what their parent left them, such as a home, they're never going to get, because they come in. I've seen letters from nursing home as high as $600,000-$700,000 that's owed because mom and dad went in the nursing home for a number of years and then pass away. And what happens is they didn't properly plan. They went in and applied for Medicaid. Medicaid will make you spend down your money, but they never talk about the real estate. So let's understand what a trust really is. A trust is almost like an alter ego where you create almost like your personal corporation and you place your items in it. With a will affects things that you own. So if you only do a will, you will own everything at the time of your demise. What I advise people to do is virtually own almost nothing at the time of your demise by putting it in a trust. So for example, which we happen to do a lot of here, especially in Queens where you have a lot of homeowners, they transfer their property into a irrevocable, not revocable trust. We'll talk about revocable for a minute, but an irrevocable trust, because an irrevocable trust has the ability to protect your assets if you transfer it into it 5 years. It's got to be 5 years because it's a 5-year look back period for Medicaid. So for instance, if your name is John Doe, you now put your house in the name of a trust, a irrevocable trust, living trust, under the name of John Doe's. John Doe's trust, and you can name your son, John Doe Jr., or your daughter, Jane Doe, as your trustee. So what does that do? Now, a lot of people say, oh, well, how can I not own my house anymore? Look, you trust your children, I hope, or you trust someone, where the property is put into this instrument, okay, where it now belongs to that and not you. So the thing is, you don't own what you put in the trust anymore. The trust owns it. You can also put money in the trust. So if you have a large bank account somewhere and you know that's that money you have tucked away that you have no desire to spend, okay, unless it's really the last possible thing you would do, you would put that money into the trust if it's not something that you would normally use. Why? Now you protected it as an asset, so that if you end up in a nursing home, they won't ask you to spend down all of your money first, because when you go to a nursing home, you have to spend down your money. And then once that money is gone, you could qualify. But if you put, that is for Medicaid, if you put the money in the trust ahead of time and it's sitting there, it can still be in the same vehicle where it's earning interest, so on and so forth. Now it can't be touched. Now, you can't receive the principal from it. You can receive the interest, but you can't touch the principal on it. And if something happens to you now, whatever assets you put in the trust automatically go down to whoever you leave it to. So if you're leaving it to your children, that's a great thing, where it passes on to them, right? At the time of your demise, if you've been in a nursing home or you get even community care at home, that asset cannot be touched. There's no lien will go against it. Any money you put in, that lien will go against it. Now, with regards to certain accounts, which might be annuities, 401ks, you do have to be careful because remember, if you put that money in the trust, it now may become taxable. So I don't advise people to run out and just put all their money into a trust. I would say you have to really think about it. Now, I have heard people move lots of money into a trust and pay the taxes on it because they wanted to make sure they preserved it for their children, okay? Now, the thing about putting real property into an irrevocable trust is that now you won't be able to do certain things. For instance, refinance it. Banks don't do that anymore. Once there was a bank some time ago, a mortgage company that did it, but most banks will not refinance your property. So that is something you have to decide whether you want to do or not. You would have to take it out of the trust, and that's a big headache because technically all of the beneficiaries are supposed to sign off. Technically, they're supposed to sign off to take it out and then put it back in. And then you start the clock to running again. So that is a downfall to the trust if you call it that. But most of the time, people who are in senior life are not looking to refinance their property because they want to be debt free or they're living on fixed income and they won't want to go back and take a loan out. Now, if you put it in a revocable trust, you can do that. The banks will allow you to refinance in a revocable trust. Most banks will. But with a revocable trust, you remain in control. Now, for younger people who still have young children and they're just worried about something happening to their spouse or their children, if something happens to them, I would recommend a revocable trust because you can refinance it, you still remain in control. It's a good thing to have. Now, the reason if you are young and you have young children, a revocable trust might also be good is because if you have real property, which is in the name of both spouse, okay, I've had situations where the court intervened because there were young children. I had a couple who purchased the property before they got married, and what happened is they never transferred it back to themselves as tenants by the entirety, which means one would receive the property if the other died. So when one spouse passed away, in that situation, the court required that guardian be appointed and that when the remaining spouse wanted to sell the house, half of the money was put aside for the children. Those sort of things can happen. Now, if you do a revocable trust, you can prevent that. Or certainly you should try to take the property as tenants by the entirety to avoid that. But a revocable trust is still a good tool to use as opposed to a will. So that's where I think you should focus on. So what are we saying about trust? You avoid probate. You avoid unnecessary fights. I find there's always fights over the real property. So very often you have parents who want to leave the property to all their children. Well, what I would recommend in that case is you put it in trust and somebody's in charge. And the trust would basically say, well, if you want them to have it for the rest of their life or live it in the rest of their life, there's still someone in charge who says, okay, as long as we pay the taxes on this house and everybody's contributing, then we'll keep the house. If that's not working, then in that case, then the house will be sold or one of you can buy the others out. But the beauty of that is that you have someone already in charge to make those decisions as opposed to going through probate. People who leave a house to multiple people in a will are vying for trouble because almost always it becomes a fight. The probate or administration process will be tied up just for strategic reasons. So one person can maybe live in the house much longer than they should, and taxes and water bills tend to run up. When it's in trust, that really can't happen because the trustee has the power to evict, whether they're siblings or not, whoever remains in the property. So once again, it's a great thing to have. Now, Another reason I've recommended trust was life insurance trust. I'll come to in just a second. For high-end clients who are ending a considerable amount of money, who have assets which exceed the New York State tax threshold, who could end up paying a very high estate tax. I recommend life insurance trusts. I've done it for some of the athletes who have digit figures in the millions. And by doing that, you can set up what's called a life insurance trust, where you can take out a huge life insurance policy, and they pay on the huge life insurance policy, so that if something happens to them, the life insurance policy basically goes into the trust and taxable and pays any tax that's on the estate. So that's a quick way to do it. But overall, I say the trusts are the way to go. And I can speak on a few more things, but I think I've exceeded my 15 minutes, and I'll pass it on to our next speaker. Thank you.
Thank you, Everett Hopkins, Mr. Hopkins. But all of your information is important. Feel free to go on for a few more minutes. And
okay, thank you. I will, because one of the things I see people do is do life estates with deeds, and it was called in law school the poor man's trust, and I kind of urge people not to do that, where you put a child on the trust, on the deed, or they put a few people on the deed and they take back a life estate. Why is that a problem? Well, it could be that the children may have some financial issues, all right? And if they have financial issues, parking tickets, or they have judgments against them for not paying their student loans, which I've seen quite a bit of, as well as credit card debt, that attaches to the property. So already, you have a problem doing that. But the other thing is that if you maintain a life estate in the property, that's still something that Medicaid can look at as an asset, because I've handled more than one matter where someone went into a nursing home where they had a life estate on the property, and Medicaid saw it as an asset and took a look at what their age was, what the approximate value would be if they remained in the home as a tenant in the home, and they calculated that out to saying that this is worth X amount of money that needed to be reimbursed back to Medicaid. So it's not really a great idea. And like I said, having multiple people on the deed is really a terrible idea. All right. And I'm coming down to now what I say, avoid the emergency quick fixes. Okay. I know we have other presenters who will fix on this, but who'll speak on this, but what we really have to do is think ahead of time. I have a lot of people who walk in who says, Dad's going in the nursing home tomorrow. This is not the time to plan. That's why I urge anybody who's north of 60, really late 50s, to begin thinking about moving into the direction of a trust, because the emergency fixes are generally not good. You may have to convince, if you do a transfer like to a child, whether or not that child actually took care of the parent for several years. That it may work, but it's not the way you should look at things. If you simply plan ahead, it's just so much better for you to do just that. Also, I encourage those who are over 60 to begin looking at putting people on your checking accounts. Now, not necessarily as a beneficiary, but a co-owner as the account. If for no other reason, if something happens to you, then that person can operate, pay your bills, possibly do something with regards to your funeral. Although you may have a policy, you may have to wait for the policy a little while. You can start moving and doing things and making sure that your bills are paid so no liens or judgments come against the estate. So I urge everyone to really consider adding someone to your checking account. You know, sometimes we operate under trepidation, shall I say, and fear. But the bottom line, you should try to find someone you can trust. And again, I find mostly a child seems to be, not all the children, but one of them usually comes through and assists you in doing that sort of thing. So I also urge, and this doesn't happen often and probably doesn't happen a lot at all, but I've also seen situations when people have transferred property to their children that they received a letter whether or not a gift tax was paid. Now, I'm not going to terrify people about that because I've seen that very little, but I have seen it happen. All right. Someone sent me, what's this, child support? Adding myself to parents' checking account is one of the best decisions we ever made. Okay, thank you. Now, with regards to child support, I'm not sure why somebody sent that, but yeah. Again, adding children or other people to your deed can cause that kind of problem. Also, the banks frown on it if they find out about it. Again, that's not something that happens often, but it can happen. If you transfer in a trust, you're generally not in violation of your mortgage agreement, without a doubt. All right. I'll stop there. I'm good. Thank you.
Thank you so much, Mr. Hopkins. You always walk with a wealth of information. It's no mystery why you're affectionately known as Mr. Mayor.
Thank you.
We're going to put everyone's information, all the presenters, we're going to put their contact information on the screen at the end of the presentation, their name, address, phone number, email address, website, so you can contact them.
Could I make just one more comment? Because I think it's important. Someone asked me what happens if you have a child on a deed with a right of survivorship. Okay, I'll run through that very quickly. Well, it's what it means. If the child survives, and this again is part of the problem. If you put a child on a deed and they have a right of survivorship and you have multiple children, then that property belongs to that child. If they have judgments, then it goes against the property. And that's why I say transferring to children is not the way to do it, to put it in a trust. I hope I answered your question. Also, if you give it to them as tenants in common, meaning there's no right of survivorship, you still run into similar problems. You have multiple owners. It just doesn't work. I'm done.
And I just want to thank you, Mr. Hopkins. And I want to remind the audience just to put your questions in the chat and we will get to every one of your questions. All the presenters will. So thank you. And now we move to the esteemed Carl Forbes Jr. Carl Forbes Jr. is the founder and managing attorney of CFJ Law PLLC. He is also a husband, a father, brother, son, Jamaican citizen by heritage, and a first-generation American. While not born in Jamaica, Carl experienced the next best thing, which is being born in Brooklyn, New York. Shout out to all the people on the Zoom from Brooklyn. The People's Republic of Brooklyn, as it's affectionately called, is home to Black families from across the diaspora that includes a strong and impactful Caribbean community. This is the home base where Carl's firm provides legal services focused on real estate, estate planning, probate and estate administration, estate litigation, and guardianship throughout New York. Carl is the immediate past president of the Metropolitan Black Bar Association, New York State's largest predominantly Black bar association, whose purpose, among other things, is to advance equality and excellence in the pursuit of justice. He serves as a member of the New York City Mayor's Committee on City Marshals, is a former adjunct professor of law at New York Law, and is a member of Kappa Alpha Psi Fraternity, Inc., the Bronx alumni chapter. Carl has received several accolades, to name a few: the National Bar Association's 2023 40 Under 40 Nation's Best Advocates, the City and State's 2023 Law Power 100, the Caribbean Life's 2023 Caribbean Impact Award, the New York Carib News 2023 and 2024 Caribbean American Power 100, the Lawyers of Color's Hot List of 2023, the National Black Lawyers Top 100 list, that's from 2021 to 2025, and the New York Metro Rising Star by Super Lawyers from 2019 to 2024. Carl Forbes Jr. received his BA cum laude in philosophy, politics, and law from Birmingham University, and his JD his Juris Doctorate from Columbia Law School, where he has a Harlan Fisk Stone Scholar. So, ladies and gentlemen, I present Carl Forbes Jr. to you. He will speak on guardianships and an overview of the court process to probate a will and for administration process. Thank you, Carl Forbes.
Thanks, Yvette. Appreciate that introduction. Good evening, everyone. Great to be here with my esteemed colleagues, friends, and those of you here for the wealth of information that is being shared. And so I'm going to actually start in reverse with the probate and estate administration. I think it's a natural progression from what Mr. Hopkins discussed in terms of estate planning via wills and trusts. And so probate and estate administration in New York takes place in the surrogates court. You may have heard the term probate court, which is what other states, many other jurisdictions tend to refer to the court as probate court, but in New York, we use surrogates court. And that's the process to open an estate. And what happens there is the appointment of a fiduciary, person who's responsible, a manager, to handle the decedent, the loved one, friend, family member who's passed away, to handle their affairs. Probate's the term for where there is a will. Estate administration is the term for where there is no will under the law of intestacy, as was mentioned before. Fiduciary is the overarching term for a responsible person. Executor is the nominated fiduciary under a will. Administrator is the fiduciary where there is no will. And the processes are similar but different when it comes to probating a will or seeking the appointment of an administrator where there is no will. What happens through this process is ultimately the court appoints someone who has the authority to manage the affairs of the estate, the decedent's affairs, such as collecting their assets, selling property, handling lawsuits, managing any and all other estate affairs, creating trusts, testamentary trusts that were designated through the will. Now, what is necessary to actually go through the process is a petition as well as supporting documents, which are going to be based on the type of process you're going through, as well as the facts specific to the circumstances. So for example, beneficiary information. If there's one sole beneficiary, you may need a certain document like an affidavit of heirship, where a disinterested party is going to certify to the court that this person is the decedent's only child. In Queens, for example, because the courts can tend to operate a little differently depending on your borough or county, in Queens, they require an affidavit of heirship on every file. The court wants to know from a disinterested party. Sometimes it can be an interested party depending on your facts, but the court wants a separate affidavit telling it that these individuals are the children or grandchildren or the predeceased spouse or a divorced former spouse of the person who died, because what needs to be presented to the court is sufficient information for the judge to say this will is valid, or the information presented where there is no will is sufficient for the administrator to be appointed and the estate to be open so that that individual has the authority to move forward with administering the estate. What is important, or one of the important things to note, which piggybacks on what Mr. Hopkins discussed, is the fact that probate, it really should be a last resort, right? In terms of if you have planned properly, if you use a trust, which is designed, one of the benefits of a trust is to avoid probate, can allow for seamless management of assets once someone has passed or even becomes incapacitated, which I'll talk more about in the guardianship section of my talk. The court process can be lengthy, even in the good times, quote unquote good times, pre-COVID. You're talking months, not days, not weeks, as people would hope. You're talking 4 to 6 months. And then through COVID, we saw a year, 2 years, 3 years. I dealt with many of the same things Mr. Hopkins dealt with in terms of the court being significantly backed up. If you have challenges, which I'll talk a bit more about, that of course is going to impact the timing as well as the cost. And so one of the highlights where if you properly plan, it may cost you more upfront in terms of creating a trust and doing transfers related to assets that are going to be owned by the trust. But in avoiding court involvement, you have some certainty there, whereas the probate or estate administration process can lead to sort of unlimited or endless costs based on the level of challenges. And so I know there was a question which I was going to touch on in terms of, well, I'm forgetting the question now, but I'll talk the point around what happens in terms of the particulars of a will. And so the question was if someone did a Staples printed a will from Staples or an online site and went through executing the will, would it be as valid as a will created by an attorney? Under the law, a will that is supervised, prepared, and the execution supervised by an attorney is presumed valid. So the individual who petitions the court to probate that will walks in with a presumption of validity that someone then has to overcome. As opposed to if you print out a will and you execute it, you have your two witnesses and a notary, but there's no attorney involved, or you use LegalZoom, for example, or one of those websites, you don't have the same presumption of validity. So the person who's presenting that will for probate is walking in, basically starting from scratch and having to prove to the court without a presumption that the will is valid. Even in an example where there is no challenger to the will, there is still things you need to overcome. So I'll give you a storied example. A woman, weeks from what ultimately became her death, executes a will that was not supervised by an attorney, and she had two children, but left everything to her goddaughter. The will is submitted by the goddaughter, who's also the nominated executor under the will, for probate. And the surviving son does not challenge, but the surviving daughter does. So first off, what happens in a challenge, to talk about the cost and time that ends up being incurred, is what we refer to as a 1404 discovery and hearing. That's the statute, the law applicable that says the challenger of the will is entitled to discovery. They're entitled to gain information about the process that was done to execute the will. So they get to take testimony through a deposition of the witnesses to the execution of the will, as well as the nominated executor in this example. So they went through that process, which is time consuming and costly. Depositions, you need court reporters, attorneys' fees related to preparing for and examining the witnesses. If the will is supervised by an attorney, the attorney who drafted the will also will testify. Here, there was no attorney. And they went through that process, and ultimately the daughter decided to withdraw her challenge. Well, her challenge was dismissed by the court for not proceeding with it following that discovery process. And so you would think then the court would admit the will to probate and appoint the goddaughter as the nominated as the executor based on the nomination in the will. However, there is a provision under the law that probate cannot be allowed until the court is satisfied, and the court does not have to deal with a challenge in order to determine satisfaction. And so I actually want to read, and normally wouldn't do this, but the language in the law, because it's clear that the court must be satisfied with the genuineness of the will and the validity of its execution. So in that example, the judge says, well, looking at the will and the circumstances, the individual died shortly after executing the will. Her handwriting in terms of her signature and writing of the date is feeble. Looks like there are some issues there with her health, of course. She then passes. The court's not satisfied that the will on its face is valid. What then happens? The court now orders a hearing before a court attorney referee where the same people effectively need to testify now before the court for the judge to become satisfied that this will was validly executed and the individual who created it was not coerced or unduly influenced, or the will actually was not signed by someone else as a fraudulent instrument, things of that nature. That creates years and thousands of dollars, tens of thousands of dollars in cost to go through this entire process without a guarantee then that that will actually be admitted to probate. And so it could end up then with the law of intestacy controlling. And so attorney supervision, for what it costs, is critical because it gives you that presumption of validity and can help avoid some of the challenges, some of the sunk time, costs, resources around the process for probate and estate administration. And so while I will echo the fact that proper planning and using testamentary substitutes such as trusts and named beneficiary designations are critical if you're in a circumstance where a will makes sense for you, or you want a will, or the assets end up needing to be probated, the will despite having these other things. Keep in mind some of these challenges that you can ultimately face. And even in the circumstances where things are straightforward, you're still talking months, not days, not weeks, where the other, those substitutes are designed to sort of move a bit more quickly. Shifting then to guardianships, which is not dealing with while someone has passed, but while someone is alive. This also plays into what Mr. Hopkins talked about around planning via will, trust, or advanced directives, such as a healthcare proxy or a power of attorney. So guardianships, we're talking about adults here. We're not talking about minors and the need for appointment of guardians related to minors, but we're talking about adults. And this is a process related to adults who cannot take care of themselves for various reasons. It might be a disease, a psychiatric issue, dementia, for instance, cognitive decline, otherwise known as mental deterioration. Usually you see that more in elderly people, but of course it can affect younger adults. Developmental disabilities can also be a place where younger adults may require a guardianship. It is a court proceeding that takes place in Supreme Court in New York, in the county or borough where the individual who is the subject of the proceeding is living. The term we use is AIP, alleged incapacitated person, the person you believe needs a guardian. We allege them to be incapacitated until it's proven to the court or determined by the court that person is incapacitated, and then they're referred to as an IP, incapacitated person. That usually where you'll see the need for that. Someone who does not have a power of attorney, does not have a healthcare proxy, doesn't have both, and they are no longer caring for themselves or able to care for themselves. They need assistance with their personal care in terms of toileting, bathing, cooking for themselves. They need financial help. They're not paying their bills anymore. They're facing eviction potentially because they're not doing anything to manage their affairs. One of the places that a guardianship can become necessary, oftentimes people will call or say, hey, I want to create a power of attorney for my parent. And then you learn that parent has Alzheimer's or dementia, and it's progressed to the point that they don't have the legal capacity, the mental capacity under the legal standard in order to create a power of attorney. And you cannot create a power of attorney for someone else. So child can't come in and sign a power of attorney giving that child power over their parents' affairs. It's the parent who has to come in and do that to appoint their child as their agent or attorney in fact in order for that person to be able to handle their affairs. So guardianship becomes the alternative where that person does not have the capacity to execute those advanced directives in order to benefit themselves. And so it requires a petition to the court. You file a petition. Almost anyone can file a petition alleging that someone needs a guardian. You don't have to seek to be that person's guardian as the petitioner. Many times people do. It's usually a family member who is petitioning, but I've seen hospitals, a hospital patient who is ready for discharge but needs long-term care. The hospital can't just discharge them to a facility, and so the hospital petitions for a guardian to be appointed in order to then do discharge planning and discharge that person to a nursing home or other skilled facility or to their home with home health aides or 24/7 care in their home. What happens after the petition is filed is the court will issue what's known as an order to show cause. It provides the information to the alleged incapacitated person regarding the petition that's been filed, the hearing that will be scheduled or is scheduled per that order. It also appoints an attorney for the alleged incapacitated person, as well as a court evaluator. The court evaluator serves as the court's investigator, speaking to the parties, the family members involved, anyone that they can talk to identify the circumstances and then provide a report and recommendation to the judge in terms of whether a guardian is needed and who the court evaluator would recommend to be the guardian. Then a hearing will take place. And so think of it as you would a trial. Mr. Hopkins mentioned that certain things are Hollywood. You can think about Hollywood in a little way here, except that most guardianship proceedings take place as what we would call a bench trial. It's just the judge who is the fact finder. You can have a jury, but most times the hearings take place just before a judge who is going to listen to testimony from the petitioner, from anyone else who is interested or presented by the parties to establish that the individual, the alleged incapacitated person, is in need of a guardian. And then the court will make a determination. And if the court finds the individual needs a guardian, the court will appoint who the judge or who the court sees as in the best interest of that individual, who we now refer to as an IP or a ward, who the guardian of that ward should be. Preference is given to family members, but sometimes the court will determine that is not appropriate. Sometimes you will have battling family members who have cross-petitioned in order to be the guardian, and the court will determine who is best suited. Sometimes the judge will appoint co-guardians. Sometimes the judge will appoint one guardian of the person to take care of their personal needs, determine where they live, if they should go into a nursing home, if home health aides are needed, and the court will appoint a separate guardian of the property, someone to manage their finances, to pay their bills, to collect their income and deposit it in the bank, to handle anything else, financial or property management, to sell their real estate, to mortgage their real estate if money is needed, to make sure there's insurance in place, things of that nature, to do Medicaid planning, which Ms. Hobson-Williams will talk about in a bit, but that's something the guardian can have power to do. And the powers under a guardianship come through the court. So the court can limit how much power a guardian has, can expand the extent of the guardian's powers as long as it comports with the law. Some of the responsibilities guardians also have is to file annual reports to the court. So you don't get to just go off and do as you please. You have to check in with the court annually by providing a report. There are requirements like you have to visit your ward 4 times a year. or at least 4 times per year. And so you have to, in your report, certify to the court you are doing that and you are meeting your obligations, as a guardian. Because we're talking about estate planning, and I know that deed theft is, of course, of great concern, guardianships are one of the places also that can be useful in avoiding deed theft. Oftentimes, what happens with our senior community is they're susceptible to scammers, right? Who will seek to take advantage of them by presenting a document to them and telling them it's one thing when it turns out it's a deed transferring their home to that scammer. Or they go the route where they just forge that individual's signature, find an unscrupulous notary who will notarize despite the person not being who's signing not being the person whose name is on the deed or who owns the property. And so if someone is under a guardianship, the court has determined they're incapacitated and their name is signed on a document like a deed, that can be invalidated because they don't have the ability as an incapacitated person to sign legal documents. Their guardian has to sign legal documents on their behalf. And so that helps in terms of potentially avoiding deed theft that can take place in one of those two or other ways. And so I'll stop here and then look forward to answering questions in our Q&A section.
Okay, thank you so much, Mr. Forbes. The information just keeps spewing out, and we've got a lot of questions. So I'm just reminding everyone that we will be fielding those questions at the conclusion of all three presentations. So I am pleased and proud to introduce Tanya Hobson Williams, the principal attorney at Hobson Williams PC. Tanya Hobson Williams is a principal of Hobson Williams PC with offices in Queens and Brooklyn. She is licensed in New York State and Maryland and has practiced for 29 years. She is a certified estate planner with the National Institute of Certified Estate Planners. Her practice concentrates primarily on elder law, trusts and estates, and Article 81 guardianship matters. Appointed to the bench by the Board of Trustees in 2008 and elected in 2009, Ms. Hobson Williams was the first African-American female justice in the incorporated village of Hempstead before leaving the bench in 2013. She is a faculty member for Lawline, giving continuing legal education presentations on Medicaid, estate and guardianship issues, as well as estate and guardianship issues to attorneys. She has written a number of articles on guardianship practice in New York and Medicaid planning for seniors. She speaks regularly at colleges, universities, financial institutions, and senior centers throughout New York and Maryland. Attorney Hobson Williams serves as counsel to judges, other attorneys in Article 81 guardianships, and a number of celebrities involved in high-profile guardianship matters. And she has an interesting saying here from the Bible: a good man leaves an inheritance to his children's children. Proverbs 13, verse 13 and 22.
Okay, well, thank you for having me. It's always a pleasure to come out to the communities and speak on these very, very important issues. I am going to speak about Medicaid this evening. And before I get into the meat of it, I just want to give a little context to Medicaid. So according to the New York State Department of Health, there are between 4 to 5 million people in New York City who receive Medicaid benefits. So I want you all to listen to these numbers. 71% of adults who are not disabled receive Medicaid benefits. And over 70% of people in nursing homes rely on Medicaid in order to pay for their care. And if you all are paying attention to the news, on the table are some significant Medicaid cuts, right? That, if put into place, will eventually affect New York and New York City Medicaid recipients. The proposal is to cut $880 billion over the next 10 years from the Medicaid budget. So I say all of that to say, if you or someone in your family might be interested in applying for Medicaid, either to pay for home care services or nursing home care services, now is the time to do it before these cuts take place, because we don't know if they will take place, and if they do take place, how they're going to trickle down and affect us. New York City, well, New York State actually has the most robust Medicaid program in the country. So I speak to a lot of people, and my mother, she was in Maryland, and my grandmother was in Maryland, and we tried to get the same type of services, home care services, for my grandmother in Maryland as we have here in New York, and we just couldn't do it because the program is not the same, particularly in the South. So I urge people that if it's something that they think their family might need, that they need to have a consultation to see if it's something that's viable for you or your family. I worked for the New York City Human Resources Administration, which is the agency that administers the Medicaid program. Medicaid is a joint program funded by the federal and the state government. And New York City, in the boroughs, administers the program. And in Nassau County and Suffolk County, it's the Department of Social Services. But New York City is now referred to also as New York City Department of Social Services, but it's also the Human Resources Administration. So essentially, I'm going to give you some parameters on eligibility for either nursing home Medicaid or home care Medicaid. And I want you to understand that the rules are different depending upon which program you're applying for. And before I start, I also want to preface and say that sometimes if you go to an attorney who specializes in Medicaid planning, asset protection, but specifically Medicaid, an elder law attorney, the information you may get from them may conflict with what an estate attorney tells you to do for estate planning. So sometimes they don't mesh together. So I want to preface that, because I know that Mr. Hopkins strongly opposes life estate deeds. However, sometimes we do recommend that when we're doing some Medicaid planning. So I just want you to keep that in mind. So you will get some different options and advice. So just keep that in mind. Medicaid planning leads you in a direction that estate planning may not lead you in the same. They could, work together, but sometimes they don't. Essentially, when we're talking about Medicaid for home care, nursing home care, an individual has to be over 65, disabled, and either a U.S. citizen or a legal resident in order to qualify. For both programs, there are income and resource qualifications that you have to meet. So I want people to also understand the distinction between Medicaid and Medicare. A lot of people confuse the two sometimes. So Medicaid is what's called a means-based program, meaning it's means tested. They look at your income and your resources to determine whether or not you're eligible. Whereas Medicare, when you turn 65, generally you qualify to receive Medicare benefits. You can also receive Medicare benefits in some instances when you're disabled. So, but we're not going to talk about Medicare. We're focusing on Medicaid. We'll talk first about home care. So home care services are when you receive care in the home. It's supposed to help you age in your home and to avoid going to a nursing home. So one of the programs will enable you to get a home health aide, which is an individual who can come into the home and provide, they can do light duty cleaning, they can help with toileting, bathing, dressing, feeding, transferring, which are referred to as activities of daily living. So they come into the home for a specific amount of time, and they can provide those services to you to keep you in your home and avoid nursing home placement. So what typically happens is when you come to an attorney, we look at what income you have. So we look at whether you have a pension, whether you have Social Security, whether you have any income from an IRA or an annuity, because all those things are added together in order to, and they look at the gross amounts to determine what your gross monthly income is. So right now for home care, Medicaid eligibility standard for income is $1,800 a month. You can't have more than $1,800 a month and qualify for Medicaid to pay for home care services. So most or many of the people who come to me have income that exceeds that. So one of the myths that circulates is, oh, I don't qualify for Medicaid because I have too much monthly income. So that is not necessarily true. So what happens is if you have income that exceeds $1,800 a month, the amount that is over the 1,800 is called your surplus. And what we do is we tell you to take that surplus and deposit it with what's called a pooled income trust. And it's called a pooled income trust because they're operated by not-for-profit organizations, and they pool all the applicants' money together in order to operate. And so that's why they call it a pooled income trust. So whatever income exceeds the $1,800, you send it to the pooled trust company, and you also send them bills, your monthly bills. So whether it's rent, your mortgage, your cable bill, your gas, your electric, if you have any insurance premiums. So you want to send them all those bills. They'll take the money that you send to them every month and they'll use it to pay the bills that you send them. So one thing that they're not going to do, they're not going to pay out more than what you send them. So people sometimes they'll say, oh, well, I have bills that are $5,000 a month. Well, if you're only sending them $4,000 a month, they're not going to come up and pay the additional $1,000. So whatever you send them, that's what they're going to use to pay your bills. And so what Medicaid does is they allow that. They say, okay, so you've put that surplus, that extra excess income into the pooled trust. Now you're down to the $1,800 that we allow, so that you keep that $1,800 in your bank account and you can use it for whatever. Because remember, all your other household expenses should be paid for by the trust because you're giving them your money and they're paying your bills. So you have $1,800 to do what you want to do. Now, pooled trust companies, they're not going to, if you send them a bill for alcohol, they're not going to reimburse you for alcohol. They're not going to reimburse or pay for cigarettes or things like that. So you need to keep that in mind. So that's one criteria that Medicaid looks at when you're applying for Medicaid for home care. They look at the income. After that, they look at what's called resources. And resources are your bank accounts, your checking, your savings, any annuities, any IRAs, any mutual funds, any other assets that you may have. So they're going to look at that, and you have to add all of that up. They also look at life insurance policy, but they look at the cash value. So if you have a $50,000 life insurance policy, they're not going to add the $50,000 to your resources. What they want to look at is what is the cash value that has accumulated on that policy. So it could be $5,000 to whatever it is, depending on how long you've had the policy. And they'll take that amount and they'll add it to your resources. So many of the clients that I see have significant assets. And that's another reason why they feel, oh, I'm not going to qualify. I have $500,000 in the bank. I have $100,000 in the bank. I'll never qualify for Medicaid. Medicaid for home care and nursing home care for a single person, you can have, I think it's $32,000, roughly almost $32,400 in assets. And that amount increases typically every year. So for 2025, you can't have more than $32,000, roughly $400. So if you have $500,000 in the bank, obviously you have more than the 32,000. So what we do then, that's where the planning comes in. So none of what I'm going to tell you is legal advice, and I don't want you to take what I say and try to execute it on your own. It's very important that you speak with someone who knows what they're doing, because there are consequences for transferring assets, right? So we could potentially advise you to transfer some of those assets either to a trust or to a family member. But I don't want you to do that. I want you to consult with someone. So we take some of these steps to bring your resources down to the 32.4. And so once we're able to do that, and we can do that, right? You're at the Medicaid resource limit. So we took care of the monthly income by putting the surplus in the pool trust. And now with the excess resources, we're going to guide you on what you can do to bring it down to the 32.4. So if you do what we suggest today, for example, and we bring the income and the resources down to the Medicaid limit, and we do that today, tomorrow you can be eligible for Medicaid home care immediately. So there is no look back period for Medicaid home care. I'm gonna say it one more time. There is no look back period for Medicaid to pay for home care services right now, right? So back in 2020, there was a Medicaid redesign team spearheaded by Andrew Cuomo. And the purpose of that was to try to reduce the Medicaid budget. And by doing that, one of the plans was to implement a look back period for Medicaid home care. And it was supposed to be a 30-month, 2.5-year look back period. So what that means is, if I were to advise you to transfer assets, they would look at that period of when you made the transfer within the last 30 months, and they would apply a penalty to it. And as a result of that penalty, you would not be eligible for Medicaid home care for a period of time. Now, that has not been implemented yet. The last effective date of this law was supposed to be March of 2025, but there are some federal compliance issues with the state and the federal government that have to take place in order for that to become effective. And what's also on the table is there's a bill in the Senate, New York State Senate, to try to repeal it. So we have to wait and see what happens. But I want you to know that that's something that could potentially happen. But right now, there is no look back period for Medicaid home care. So we can put a plan in place today and you can be eligible tomorrow. But that's the financial piece. And it doesn't end there, right? So we got the assets and the income in order for you to qualify for Medicaid. But then there's the home care piece. And that piece requires an assessment. Now, when I started doing Medicaid back in 1996 or so, the rules were very different then. There were a lot of things that you couldn't do that you can do now, and vice versa. But in 1996, you were not able to do the pooled income trust. That didn't even exist then. So I want you to be aware of these are things that you can put in place now that will help you. When they do the assessment, New York State, they have hired a contractor to come in to determine whether or not you would medically qualify for home care services. And after that, there's another assessment that's done, typically by a nurse, and they come in and it's a task-based assessment that's done. So they come in and they see, are you able to dress yourself without assistance? Can you toilet without assistance? Are your abilities limited? Are they extremely limited? So there's a scale and they score it. And then they look at the end of their assessment and there's a score. And based on that score, they determine how many hours they believe you need. So when you typically apply for Medicaid home care, I typically go through the local agency, the local HRA agency, and usually when they do the scoring and look at it, they give you more hours, right? But it's only for a limited amount of time. So you might get 24 hours, 7 days a week. After 90 days, they send you a letter telling you, okay, now we want you to select, it's called a managed long-term care agency. It's an MLTC. And what that is, they're private contractors. It's not the local agency anymore who's providing the home care services. After 90 days, it goes to a private company. The private MLTC, they get paid what's called a capitated rate. So what that means is they reassess the individual. If HRA gives you 24 hours, 7 days a week, they're going to look at it and say, well, I think you're getting a little too many hours there. I don't think you need 24 hours. We're willing to give you 12 hours. And so they'll try to reduce the hours that were previously given to you. Why would they do that? Because they get paid a capitated rate. So what that means is if they give you 24 hours, 7 days a week, or 12 hours, they get paid the same. So they're going to give you the 12 hours if they can justify it. Now, if your hours that were awarded to you are reduced, you can always challenge it. You can do an internal appeal with the MLTC who reduced the hours. And if you're not satisfied with that, you can also request what's called a fair hearing with New York State Office of Temporary Disability and Assistance. And that is a hearing before an administrative law judge. You can be represented by an attorney, and they look at, and hopefully you'll bring your doctor in to justify why the hours should not be reduced. And so it's a hearing, and you can present evidence, and then the administrative law judge will issue a decision. So that is essentially how Medicaid home care works. But when you look at Medicaid to pay for nursing home care, that's a totally different animal. So with Medicaid to pay for nursing home care, there's a 5-year look back period. So what happens is when you submit the application for Medicaid, they want bank statements for the last 5 years because they want to see, did you give money away to children? Do you have deposits from accounts that you did not reflect on the Medicaid application? So they look line by line for every deposit and every withdrawal that exceeds roughly $2,000. There's no hard, fast rule, but roughly it's $2,000. So if you have a $5,000 withdrawal coming out, could be one time. They're going to look at it and they're going to say, what did you do with that $5,000 you withdrew? Did you give it to someone? Did you use it to make repairs in your home? You have to be able to justify it. So if you are able to justify the basis for the withdrawal, then there won't be any problem. However, if you have large deposits and withdrawals, and there's a check, for example, that says $20,000 to Jane Doe, they're going to ask you, why'd you give Jane Doe $20,000? So the reason is they don't want people siphoning money out of their accounts in order to qualify for Medicaid. So if they see that there are large deposit withdrawals coming out of your account, they're going to penalize you for that. There will be a penalty, and the penalty is a period of Medicaid ineligibility. So I'm going to use an example of a home, for example. Let's say a year ago, you transferred your house to your son or your daughter. You just, you gave it to them, and now you need to apply for Medicaid. So you have to, disclose the transfer on the application. And so what happens is they take the value of the home or whatever monetary transfer, right? And they divide it by what's called the regional rate. And that's how they come up with the penalty period. So for example, if the house that was transferred out of your name within that 5-year period was valued at $600,000, in New York City, the regional rate is $14,582. So you take $600,000 and you divide it by $14,582, and you come up with 41 months. So that means for 41 months, you are ineligible for Medicaid. So if the transfer was $300,000 in cash, take it in half. So that's roughly 20 months of Medicaid ineligibility. So what that means is typically you're in the nursing home when you're doing the application. So what they're going to do is count from the time your Medicare expires, because Medicare does pay a portion if you're in a nursing home. When that expires,
That's something. And when you work, they take your money.
we'll take the question in a minute. What they'll do is they'll look at when you entered the nursing home, when the Medicare expires, and you would have been eligible for Medicaid. So if it's a 40-month penalty, so for what is that, 3.5 years? If you're in the facility for 3.5 years, you're not going to get Medicaid to pay for it. You have to pay out of pocket. And the average cost of a nursing home nowadays is anywhere between, could be $10,000 to $15,000 a month. So if you're paying $15,000 a month and you're there for a year, that's $180,000. So if you have $180,000 in your accounts, brokerage, mutual funds, stocks, bonds, checking, savings, you're going to use that money to pay for your care at the nursing home during that penalty period. When the penalty period expires, your 41 months is over, then you would qualify for Medicaid. So as Everett mentioned, a lot of times people will come to you, they're in the nursing home, and they didn't do any planning. So that doesn't mean that, for example, if they transferred a house that was valued at $600,000, they're in the nursing home and now they have a 3.5-year penalty period. You can still take steps, right, to minimize that penalty period. If you go to an elder law attorney who knows how to make a plan that will reduce that 3.5 years maybe down to 1.5 years. It's possible. So I want you to be aware that just because, and we call that crisis planning, when you come at the last minute, the things we could have done previously, now we're in crisis, we're in the facility, and we're limited in what we can do, but there are things that we can do. Some of the transfers that Medicaid will allow, one is what we call a caretaker child. A caretaker child is an adult child, typically, who has resided in your home for at least 2 years before you needed to go into a nursing home. So the thought process behind that is if they were able to keep you home for 2 years and not go into a nursing home, they're going to award you for that. And what that means is that if you transfer your home to what's considered a caretaker child, you won't incur that penalty that I just talked about. However, again, I don't want you to go out. Okay, my daughter, my son, they've been living here for X amount of years. I'm going to transfer the property to them. Do not do that because there are potential consequences for doing that. You need to consult with someone before you take any steps. I'm just telling you things that you might want to raise when you're in your consultation with your attorney, right? The other thing you have to make sure before someone qualifies as a caretaker child that they have documentation to prove that they've been living there for that amount of time. You know, sometimes people have other apartments or other property, but they come back to their parents' home to help take care of them, but their domicile or their primary residence is somewhere else. They file their taxes somewhere else, their driver's license is somewhere else. And so you're going to have a difficult time proving that you're a caretaker child. There's also transfers to siblings who have an equity interest in the property. There's a transfer to a disabled child that could potentially be done. And then transfers between spouses. That's the big one. Those are exempt transfers. So if you're married, husband and wife, and the husband goes into a nursing home and he has, I don't know, $150,000 in his name. He's not going to qualify for Medicaid like that. So we can transfer to his wife in the community. That's exempt. There is no look back period for that. If there's property in both parties' names, you can transfer to the spouse in the community. That's the well spouse, the community spouse. So we can transfer all the assets to that well community spouse. So the good news is, when you do that, it's called a spousal refusal, right? You have to make sure you sign a spousal refusal. And there's also an assignment of benefits that you have to sign when you're doing that. So that assignment of benefits basically says, as the spouse who is in the nursing home, right? You're assigning to Medicaid, HRA, the right to support you because the spouse in the community has refused to do so. So you're assigning the right to support to us, the agency. But with that is another little provision that says we do have the right to sue you to get the money back. However, in New York City, they have not, to my knowledge, commenced any of these lawsuits since I was at HRA almost 20 years ago or so. So I was in that unit. And what we did, we filed summons and complaints, and we sued the spouse in the community because now they have all the money. They have all the money, and Medicaid has paid for the care of this person in the nursing home. So we would sue, they're like 80 years old, you know, and maybe poor health themselves, but we would bring these lawsuits against these people. So I think there was like a public outcry against these types of lawsuits, you know, dragging these elderly people into court, you know, and the thought was that, you know, these people worked hard for their money to accumulate whatever it is they have, and the city shouldn't be suing them. So right now, and they would do it for home care too. So if you did a spousal refusal for home care, that provision is in there as well. But again, in New York City, they have not been commencing these lawsuits. It may be a little different in the counties, Nassau and Suffolk. They're a little more aggressive. But I have not heard of any lawsuits recently commenced by the counties either. The other thing is, if for some reason you're in a position where there's a penalty period, it could be because you transferred money into a trust. So you got to be aware of that also. Even a transfer of real estate or money into a trust, particularly an irrevocable trust, you're still subject to that 5-year look back period, and they're going to assess a penalty. So if a person applies for Medicaid and they get denied because of these transfers, right? And you put your money in a trust, an irrevocable trust, and you can't get it out. So you're in the nursing home. So the bill accrues every month, 15,000 every month, 6 months, 8 months, whatever. And so now the bill could be, I don't know, could be $50,000, $60,000. If you're there a year, almost 200,000. What's going to happen? This nursing home has this big bill that you can't pay because your money's in a trust, right? And you can't qualify for Medicaid. What's going to happen is the nursing home is going to sue you. They are going to sue you, and they're going to sue whoever you transferred the money to. And if someone, a family member, signs an admissions agreement, you know, because you have to sign an admission agreement to get into a nursing home, and it's a multi-page document. One of those pages, typically they have you sign as a designated representative, right? That gives them the right to sue you too. So you might have signed an admission agreement to put your loved one in a nursing home. There's a bill for whatever reason. There's a bill. If it's not paid, whoever signed them into the nursing home could be subject to a lawsuit. If you are the agent under a power of attorney, the nursing home can sue you as the agent. You're not responsible for paying any bills out of your own personal funds, but as the agent, their position is that you have a responsibility to either apply for Medicaid or find whatever money the person has and use it towards the cost of care in that facility. And if you didn't do that and there's a bill that's not paid, everybody gets sued. So you want to make sure that when you're going into a nursing home, that you get the proper planning, especially like Everett said, in advance of when you need it. So, I mean, he threw out some ages that I'm a little concerned, you know, with the ages that he's saying you need to be thinking about nursing home. But, you know, I would
Thinking about it.
I think all of us then need to be doing that kind of planning. But I would say when you are in the retirement phase of your life, thinking about that, in addition to estate planning, you need to think about Medicaid planning, because if you are working with a financial advisor, you're working with a trust and estate attorney, right? And you've accumulated this wealth and you say, oh, I'm going to leave this to this one, this to that one. If you're in a facility and there's a bill that has to be paid, whatever money you have can be spent on your care, and you will have nothing to leave as a legacy for your family. So that's what I want to leave you with is, you know, we have to work together as a community. We have to work together as professionals, and you have to seek us out. You have to seek us out to make sure you have a plan in place where you can responsibly, whatever wealth you've accumulated can be effectively transferred to the next generation, if that's what you want. I have some people, they don't want to leave anything to anybody. They don't care about it. But if you want to leave a legacy for family, you need to do the planning, and you need to do it as soon as you can. Thank you.
Wow.
Good show.
Thank you so much, Tanya Hobson Williams. Thank you for that insight. So as we soak all that information in, we are going to, yes, Lisa White wrote, wow, and thank you in the chat. That's exactly how I feel. So we are going to post the contact information for the attorneys. Jace, I don't know if we should post that now and also move to Q&A session.
Well, we could post that while, I believe Lori Miller is now on the call.
Okay. Good.
And she is the executive director of Neighborhood Housing Services of Jamaica. If she isn't able to speak, because she may be in transit, then I will speak as the president of the board. Lori, are you out there? Are you able to speak on what we do over at Neighborhood Housing Services of Jamaica?
Yes, I am.
All right, there we go. The floor is
Okay, so neighborhood, again, I'm Lori Miller, the Executive Director of Neighborhood Housing Services of Jamaica. We are a HUD certified housing counseling agency. We've been serving the primarily Southeastern Queens community since 1974, have a number of housing programs. We've got first-time homebuyer, one-on-one counseling. We do monthly workshops for first-time homebuyers. We also have programs for homeowners who are interested or need to make repairs to their homes. The goal is to facilitate affordable repairs, either through grant programs, which we administer, or by connecting homeowners to other programs throughout the city. And the good thing is that, you know, of late, there have been a number of new programs that have come on board. So if someone has needs, those types of needs, you should contact us at Neighborhood Housing Services of Jamaica. We also provide foreclosure prevention counseling, and we actually consider this to sort of come under the heading of homeowner stabilization. So for those homeowners who may be at risk of foreclosure, who are actually in foreclosure, we are funded by the state of New York, the Attorney General's office. There's a program called the Homeowner Protection Program. Counseling and assistance is free. So we advise folks, if you or someone you know is having those kinds of difficulties, before you go out and start paying other parties who often are not able to do anything more than we could do, please contact Neighborhood Housing Services of Jamaica or other agencies like us. We also assist renters apply for, we are with the City of New York's HPD, Housing Preservation and Development. We are housing ambassadors. So for those in the community who are interested in applying for housing lotteries, as an ambassador, we can assist with applying for housing, getting yourself registered for those. We also help homeowners apply for tax exemptions, property tax exemptions, if they find themselves in situations where they've become delinquent on their taxes or water, sewer bills. We can counsel and work with them to try and set up a payment plan with the City of New York. So any housing need that one has, we don't have apartments, but we can make referrals if you need attorneys who are able to help with housing related matters. We can make referrals for that as well. If there's anything that we don't actually handle, we do say, give us a call, let us know what the issue is, and we will find the appropriate agency, whether it's public or private, to refer you to.
And I will place the contact information for Neighborhood Housing Services of Jamaica in the chat shortly. Okay, so we're gonna have to ask our technician if the recording will be available after we conclude, but I am gonna move on to the question and answer. And while I do that, I believe we can post the contact information for the speakers. And I'm gonna look through the chat here. Oh, when he posted that, I lost my chat. Hang on a second. Okay, here we are.
Chase, perhaps we should also, before we lose some attendance or participants, also talk about June 28th.
About June 28th. Okay. I'll let you speak on that, and then we'll go to the questions.
Yes. I'm trying to figure out how to put it.
So we're having
to go in the hospital, a nursing home.
If everyone could put their
gone to nursing home.
Okay, great.
Just one moment, and if I could just say, the question should be posted in the chat, and then I will field them to the presenters. It's going to get too confusing if everyone starts taking themselves off of mute and trying to ask questions. So we do have questions that have been being posted throughout the presentations, and I will get to those. But I'm going to let Yvette speak on our next event.
Okay, so we have a free giveaway. The Dubois Bunche Center, as well as the co-sponsors, are giving everyone a freebie just for participating in this event. And we're going to put the registration link to this information session in the chat. We would like everyone to register so we have your contact information. If you register for this event, we have part 2 of this event taking place on June 28th, at which time everyone who registers for this event will receive a free estate planning kit. And in that kit, you have pro bono attorneys preparing a power of attorney, preparing a living will, and preparing a healthcare proxy. But you must register for this event, and Aaron, our facilitator from the Dubois Bunche Center, will put that registration link in the chat. That's an in-person event. It will take place at NHS of Jamaica, and the address is 114-02 Guy R. Brewer Boulevard, Jamaica, New York. That's 114-02 Guy R. Brewer Boulevard in Jamaica, New York. We'll also have another event where we're preparing these documents in Brooklyn as well to be announced. Okay, we can move to the Q&A. Thanks, Jace. I could pose the first question. We spoke a lot about different topics, and many of the presenters are versed on all the topics. So any presenter, any panelist, feel free to answer the questions. So if a person never got a divorce, just never got a divorce, and they were married maybe 55 years ago, and they haven't spoken to their husband or their wife since then, is it true that wife can ask for part of my estate? Can that wife or husband just come and ask for part of that estate if I never got a divorce? Or is there a time frame that so long as I haven't seen him in a long time, then he's not entitled to anything? Anyone can take that.
I believe there's a provision for abandonment in the SCPA. Now, in all honesty, I've never had to use it or litigate that, but I have come across it in an estate proceeding, but I was representing a beneficiary who was not the spouse. But I'm fairly sure that one can claim abandonment in the marriage to prevent them from receiving. Yeah,
I can add to that, Everett, is the burden, though, is on the proponent of the will to prove the abandonment, not on the spouse to prove that they deserve to inherit. So the burden shifts despite the fact that that spouse might have abandoned 30 years prior. So it can again become challenging for that beneficiary or the nominated executor to establish that abandonment, or at least the burden's on them to establish it with sufficient facts.
Okay, from the chat, we have, if the attorney who prepares the legal documents retire, etc., what will happen then? And I guess assuming they have the original documents or something, what happens?
Maybe they need to add more to that question. Do they have the will? They don't have the will?
Let's assume they have the original will, and your original, your attorney who prepared that will retires. So
well, you can still probate the will. I had mentioned earlier that some attorneys withhold the affidavit of attesting witness. Now, if that's the case, you got a lot of work to do. If you have the full will, you just go to another attorney. There's no problem.
So the next question is, I know trusts protect assets, but can the government take control of a trust if they choose?
I've never seen that happen. I wouldn't imagine what the grounds would be for them to take control of a trust unless they thought it was fraud. Maybe not take control, maybe bust the trust, try to bust the trust. It's probably what you're referring to. If they felt for some reason that there's bad faith, I could see something like that happening. Yeah.
Right. I also had a person who um, told me that not an attorney, but an organization told her to transfer her assets into a trust in order to avoid the IRS. So that is something that, if it were done, I could see the IRS or any other agency or individual saying it's a fraudulent conveyance in violation of the debtor creditor law to avoid a debt.
I saw one of those too. It might be the same organization. I think they consider themselves faith-based, something like that.
So the next question someone asks, do I need to put my 401k, Roth, and individual brokerage accounts into my will or trust, or is designating the beneficiaries enough?
Well, we talked about that. That's something you really have to sit and talk with your financial planner. Remember, with certain accounts, once you redesignate it, it's a withdrawal. So in your 401k, if you transfer it or redesignate it as a trust, now you're talking about taxing it. So you got to really think through what's more important to you, paying taxes on it or protecting it. So it's not a perfect answer. You got to really look at it. It depends upon where you are in life and what's more important to you. And I would always say consult with your financial planner and an estate attorney at the same time, because you got to look at what's best for you. But you're gonna take a hit. You're gonna take a hit. It's no doubt.
The next question, as a homeowner, I believe I learned somewhere that having a trust will help my children with minimizing real estate taxes if and when they sell. Is that correct?
I'll take it. If you're talking about after death, yes, not before. It will pass as a death benefit after death. So that being the case, you would get to step up in basis, which would help. But that's after death. Before death, I would not say so.
Now, at risk, this next question, I'm not sure if it's maybe more of a tax guy's question, but adding a person to your bank account, doesn't it add to their, well, they're asking, does it add to their tax burden as income? In other words, when you add someone to your account, is it going to be counted as income towards them? And is it going to add to their tax burden?
Well, I can speak from a Medicaid point of view that if there are two individuals on a bank account, Medicaid will consider all the money in that account as belonging to the Medicaid applicant. Even if you can prove, well, some of that money belongs to me, Medicaid will still consider it belonging, all of it, to the person who is applying for Medicaid. Also, there's a recent law that was passed where you can add someone to your bank account and they're not a co-owner. It's a convenience account. And you can take them off when you pass away. The other account holder will not automatically inherit those funds. So in that scenario, I wouldn't think that there would be a taxable event to it unless you are, in fact, an owner and the account is generating income. Then I would think that the income would be split amongst the joint owners.
Yeah. The only thing I'll add to that is from an operational standpoint, not a tax theory standpoint or statute. You got to look at, is the bank reporting on a 1099 income to you? If it is, it's income. Now, if they're not, it doesn't mean, notwithstanding what Tanya says, doesn't mean it's not. But certainly if the IRS is sending a 1099 out, with your name on it, I don't see you overcoming that. I'm just talking operation. I'm not talking statute.
Just to add a practical point for people to keep in mind when designating joint owners, that joint owner has full access to that money then. So think about making sure it's someone you trust because they can clear that entire account out, whether they put money in it or not, because you've made them a joint owner. And so Tanya mentioning the for convenience designations that exist now is critical for those who are just looking for assistance in terms of paying bills, drawing money for your use, rather than actually having legal ownership over that money.
Now, the next question I think was touched upon, was discussed, but maybe the person needs a little more clarification. They ask, could you comment on what happens when a child is a co-owner with right of survivorship on a property with one parent? And in follow-up, they're worried particularly about Medicaid. Does the child that gets the property after the parent dies, do they need to worry about Medicaid putting a lien on the property?
So Medicaid will put a lien on property if they have a claim. So even if there is, if it's a life estate deed and you inherit it when the person dies, if there's a lien on the property, that lien is going to follow to you if you now own it. Medicaid will put a lien on an estate. So if there's property that, it doesn't necessarily have to go through an estate, but any real estate, any liquid assets, anything that is in an estate, Medicaid goes through estate records, and any public assistance or Medicaid recipient, if they see their name in a state surrogate court file, they can put a lien against the estate. But liens follow the property, if that answers the question.
So to clarify, with the joint of rights of survivorship, that lien would have been posted before or after the parent died?
Right, it would have to be posted before
Right.
the parent died.
Okay. And can a pre or post-nuptial avoid the elective share in New York?
Yes.
Yeah.
Yeah. So married couples or people intending to be married can use agreements to waive the right of the elective share. You can even do a waiver that's not an independent waiver that's not part of a pre or post-nuptial agreement. And so that would become evidence if that spouse decided to exercise their right of election and there's an agreement they signed, that would be used as evidence to refute their claim or their exercise of that right of election.
I want to add something there too that it should be known. The legislature some time ago put in the, I believe it's the EPTL, that once couples become divorced, even if the will indicates they are to inherit, they no longer can. Because the legislature found out people weren't changing their wills sometime, although they got divorced, they didn't think about it, they forgot about it. So now the legislature took care of that. So if they want to leave the ex something, they would have to re-execute a will after the divorce. And I had a very interesting case like that. It went up to the Court of Appeals. But we tried to, there was a situation where there was an annulment, and an 80-year-old man married a 30-year-old woman. He died, who was his caretaker. Before he died, he executed a will, leaving her everything. The family came in through a guardianship and had the marriage annulled. And of course, the will remained intact and she couldn't receive anything. They say he didn't have the ability to get married, the requisite intent. Although he had done 3 wills before he married her, leaving her everything. But by voiding the last deed, she could get nothing. We tried to appeal it, indicating that if you didn't have the intent to get married, then the other will should stand. The
That's
court-
common.
Yeah.
Everett, that's a very common scenario that you
Yeah.
just described.
Yeah.
And it happens in what I see is mixed race
It was.
relationships.
Yeah. Yeah.
Mhm.
Not sure why, but it was in this case. It absolutely was.
Question is,
So, oh, Yvette, you're going to take the next one?
if you move out of New York, do you need to generate a new trust or even a new will in the state you relocate to?
I'll start. I always say consult with an attorney in the new state. Always start with that. However, the trust you did is still valid, and it usually says that it will interpret the trust from the state it was executed in. Now, you have to take a look at whether or not that's still good for you and whether or not the state you're in now will do you better. So that's the best way I can answer that, because the laws are different in certain states. Like Atlanta is very much different, or Georgia is very much different than New York. So you might want to reconsider, especially when it comes to spouses and their rights to live in the house and all that sort of stuff. So I would say always consult an attorney in the new state. The trust is still valid, and it usually say it'll be interpreted under the laws of the state of New York, but then whether or not you move to Delaware, Georgia, South Carolina, you need to look at whether or not those laws will do better by you for your situation.
Jace?
You've got to follow up that. Is it smart to have a separate trust for each asset or putting everything into one trust? Wondering whether separate trusts add an extra layer of protection.
Great question. You know, it really depends. If you own multiple properties and you're renting some of them, I would suggest separate trusts because you're minimizing your liability. Because they will sue the trust if something goes on, and then you have all your assets in one trust. So I would say I would have separate trusts for sure. I would recommend separate trusts for that purpose. Anybody else?
Yes, I would like to ask a question. In short, hopefully I can make it as short as possible. My husband and I purchased a house with my in-laws, which is his stepfather. Presently now he is under my mother-in-law's care. She's the power attorney. Now he has dementia. However, he do have two biological children, which are grown, um, that we never see too much. So my concern is now my mother-in-law and myself are both on the deed of the house. Now, my question to you is, what is it exactly can my mother-in-law do to protect herself into being in control? Because we are looking forward in the near future to sell the house and relocate.
So I'm clear. Who's on the deed?
All four of us are.
You're saying someone is on the deed who has dementia?
No, my husband and I, their names are both on the house that when it was purchased, but my mother-in-law and I was added on the deed.
Oh, I see.
Mm-hmm.
Well, I guess it depends upon what it is you want to do.
Well, my concern is, and hers as well, is what exactly can she do to, I guess you would say, God forbid, if something were to happen to him, where she would be in control if we, once we decide to sell, or even if God forbid, something happened prior.
He's not on the deed, correct?
My husband and all four of us are on there.
No, I understand, but
No, he and my husband
So
purchased the
I'm
house. But
sorry. I have to interrupt because we are over time. And we are trying to get to the more generalized questions. We did post the speakers' information, and we encourage you to reach out to the speakers to schedule consultations or opportunities to speak to them about specific issues. But we're trying to keep our questions more generalized so that everyone on the call can benefit. So I apologize, but we will have to move on to a more generalized question.
There's another question in the chat. It says, are the services that are offered by NHS Jamaica only reserved for residents of Jamaica, of Queens, or specifically repairs assistance?
Do I still have Lori Miller on the line? If I do not, then I will answer that question. It's not limited to just members of the Southeast Queens community. And if logistics is an issue, there are different neighborhood housing services of Jamaica in different boroughs, not necessarily related, but as Ms. Miller said, if you reach out, they often will help you find something local if need be. If they can't satisfy your service, your issues, they can refer you out. Does that answer your question?
And let me just jump in. I had trouble unmuting myself.
Okay.
Yes. No, our services are not limited to just Southeastern Queens. For the home repair grant program, which is funded by the Affordable Housing Corporation, our service areas are Queens, Brooklyn, and the Bronx. We don't do Manhattan or Staten Island. But as I'd said, there are a number of programs, and as Jace referred to, there are other NHSs throughout the city. There's 2 in Brooklyn. The one in Staten Island is no longer called NHS of Staten Island, NHS of New York City. And we all have similar, but often different programs. So you can reach out to, any of them. And what I would advise you to do is actually you can go on to HPD's website, and you can treat it really just like Google, and you can type in home repair programs or nonprofit housing agencies. And you can also go to HUD.gov and look up HUD counseling services agencies. And that's not just for New York City, that's all over the country. And it'll give you a list of, our various programs, or just call us. Yes, HUD.gov.
Another question.
Yes, I see a question here. Is there a requirement for trusts to be registered in order to be valid? If registration is required, where does registration take place?
There's no registration of trust. One of the benefits of trust compared to wills and other things is the private or general private nature of them. Unlike an LLC, for instance, if you were creating an entity that has to be registered for the state. Trust is a declaration or an agreement between the grantor and the trustee that at least generally remains private. You may have to share it with certain institutions. You're doing a deed transfer to the trustee, for instance. When you file to record the deed, you have to present a copy of the trust, or can attempt with institutions to provide a memorandum of the trust. And so there's some, pseudo-public exposure, but there's no registration of it, generally.
Next question. Can you appoint an entity as a trust executor versus a person?
Yes. But it may cost you a lot of money.
Thank you.
Okay. And can you explain the difference between a pooled income trust and a supplemental needs trust, if there is a difference?
Yes. So a pooled trust is designed specifically to decrease the assets that an individual has to bring them down to the Medicaid limit. And as I had said, the surplus, the amount over the Medicaid limit, the currently 1,800. Anything over that goes to the pooled trust. The pooled trust uses that money to pay an individual's bills so that they can qualify for Medicaid. A supplemental needs trust is a trust that can be created by the individual. It can be ordered by the court, or it could be created by a third party. And the purpose of a supplemental needs trust, also sometimes called a special needs trust, is to allow an individual who may be disabled, right, to the money in that trust is to supplement their needs. So they're not supposed to get money directly. Payments to them should be in kind, because the assets in a supplemental needs trust enables a disabled person to have these monies and also maintain either their Medicaid benefits or their SSI benefits. So it's a way to have access to funds and assets to provide for a disabled person, but also maintain their government benefits.
Thank you. I think we have the registration link working. We're putting a new link in the chat. We're going to take maybe a few more questions, about 2 or 3 more questions. We have to respect the time of our panelists who are with us today. Jace, do you have a few more questions, or you want me to?
After a long day's work, the panelists have stuck with us through to almost 8:30. So we're just gonna take a few more questions. I'm just quickly scanning to see if there's anything that's not redundant. Okay.
One is, does adding a person to your bank account add a tax burden, such as an income tax?
We discussed that earlier.
Oh, we did. Okay. Sorry.
Yeah.
Okay.
Okay. I think we may have covered it.
Done it.
If you had a question in the chat and you feel it was missed, you can quickly repost it in the chat. But I think someone did ask, home care is different from nursing home care, and I think that's clear. But I'll let Ms. Hobson Williams just say something quickly on that.
Right. So as the name says, home care is provided in the home to maintain a person, to assist them with their activities of daily living so that they don't have to go into a nursing home. And the Medicaid that you apply for to receive that is different. That's called community Medicaid. Medicaid in a nursing home is the type of Medicaid that's subject to the 5-year look-back period. And that it covers the cost of care for the individual while they are a resident in the facility. The difference, I would say, is with respect to income. So whatever income the individual receives, pension, Social Security, all of it goes to the nursing home, with the exception of $50. And that $50 is used for haircut, nails, incidentals. But the thought process is, the nursing home is providing, a place to live, room, board, everything. So they don't need that monthly income. Sometimes that raises an issue if they have a spouse in the community who was relying on that income, to pay some bills. But, in certain circumstances that can be addressed, but the Medicaid for each program is different.
Thank you, Ms. Hobson Williams. So there's a question here about guardianship. It appears someone may or may not have a guardianship over someone with a special needs adult, but they are asking, does guardianship affect Medicaid capability or negatively affect that person in a trust? I guess the special needs adult that has, a guardianship. It's a little bit of a mixed question, but
well, with respect to the Medicaid, if someone has petitioned for a guardian, and the alleged incapacitated person who may then become an incapacitated person, needs Medicaid, you can apply for Medicaid for that individual because of the guardianship. And it's an exception to policy. And typically you can get Medicaid automatically on the basis of having a guardianship. And that's typically for Article 81 guardians. Now, there are guardianships under Article SCPA 17 and 17A, which are done in surrogate's court, but we're not talking about that tonight. But in terms of Article 81, you can get Medicaid for an individual who's subject to a guardianship. I don't know about the other part of the question.
Real quickly, while we're looking at that question, do you have to notify your insurance company if the house is in a trust?
It would be wise to do it. Yeah. It'd be wise to do it. Now, in operation, I've never seen anyone turn down when they had a problem because they had transferred into the trust and didn't tell them, although they should have, because they were still a beneficiary of the trust. They just had to explain it to the insurance company, but I think it would be wise to do just that. They don't charge you anything for it, so you should do it.
Maybe just one more question, Jace.
Yes, well, I'll grab the last one. Can an irrevocable trust take out a mortgage? I think Mr. Hopkins spoke on that, but it was a little unclear. People seem to be concerned. There are a few questions in the chat about what you can do with the property once it's in, and if we can make a distinction once it's in a revocable trust or an irrevocable trust. And that will be our last question for the evening.
Okay. With the irrevocable trust, mortgage companies will not lend to you. They've stopped doing that. About 20 years ago, they did. They stopped. So if you put it in an irrevocable trust, you will have to take it out to refinance it. That's really the only impediment to it that I can think of, other than understanding that you're giving control over to the trustee. You got to be clear about that. You're not in control anymore, but they're your trustee. You're supposed to trust them. So you have to pick somebody who understands what you need and what you want to do. But that's about it. I'll tell you now also, the city has become savvy to trust. There was a time when you would file deeds for trust and they would keep rejecting the deed because they didn't understand trust. The city of New York actually didn't understand how you were transferring things into trust. We used to run into that all the time. But they've finally gotten savvy after we talked to Corp Counsel over a couple of years, and they get it. But no, you can't refinance. You have to put it in a revocable trust if you want to refinance without having to take it back out.
And just a quick follow-up with that. I know I said that was the last question, but I recall there was a question in the chat that asked about putting a property that you're currently paying a mortgage on. So you're not looking to refinance it, but you're paying mortgage and putting that into a trust. And if you could speak on the notification issues with the lender and where that may be.
Yeah, I spoke on that. No, the banks don't have an issue with that. Okay, you don't have to call them. You don't have to notify them. In fact, I suggest you don't, because depending on who you get, you might confuse them. But they don't see that as a transfer in violation of your mortgage agreement. Okay, actually, when you do deed transfers and add people on, you're actually in violation of your mortgage. Now, it's just that. Oh, you absolutely are. It's just that banks generally don't care, and they really don't want you to tell them. I'll just share this one case with you. Someone came to see me once who transferred their property and added 2 children on and wrote the bank and told them. They got a call or a letter from a bank attorney telling them they were going to foreclose on the property. They brought the letter to me. I looked at it. I called the attorney for the bank, and he said to me, and I quote, "Why would anybody want to tell the bank this? Why did they tell us?" He says, "All you have to do, counsel, is write a letter to me telling me that your client intends to transfer the property back. I don't care what you do after that. Just send that letter, and it's up to your client what they do. If you send me the letter, I will close my file." That's pretty much a direct quote. So, just so you know, when it comes to the trust, they don't care at all. Actually, don't care at all anyway, but it's not a violation to transfer into a trust.
Rick Hopkins Jr., Carl Forbes Jr., Tanya Hobson Williams. Thank you, thank you, thank you, thank you. The community appreciates you. We thank you. The participants are. I also want to thank the Dubois Bunche Center for Public Policy for Medgar Evers, the NHS of Jamaica, Macon B. Allen Black Bar Association, and the UNCA, United Neighbors Civic Association. Thank you, thank you, thank you.
Thank you all, and thank you, Yvette, for bringing this to the community.
Fabulous.
Jason?